gridlock, and some are saying, watch it. Parliament will not be able to reconvene until the 6th of January. The majority group, so I call them majority because I know that by law, the Supreme Court's orders, whether they are illegal, whether they are wrong, whether they are unconstitutional, to the extent that they have not been set aside, they are binding and ought to be complied with. And since they have been served on the Speaker, the status quo has reverted. The MPP is in the majority, the NDC is in the minority, until and unless they have set aside the orders or they have taken steps to set aside those orders. Now, you don't disagree with me yet. You have the opportunity to discuss this. You have the opportunity to discuss. Kofi. I'm just introducing the subject for you to begin your discussion.
I will make a case why I disagree.
Okay.
Maybe outside Parliament.
All right.
Let him.
Thank you.
Let him introduce
Thank
the
you.
topic for us to discuss.
And what I said, we want people like Afenyo Marking and the majority group to also respect multimedia, because multimedia is not one of those common places. They have lawyers who are worth their salt. So if you hear multimedia journalists on the day the Speaker made the declaration say that the NDC was the majority, they are fortified in law, plain and simple. You can't call the journalists, berate them, and tell them they are doing NDC bidding, because at the time, in fact, and by law, the majority was the NDC. If the majority was not the NDC, why were you in court? What's the use of the orders you got from the court? So you use that and tell the journalists that they are doing NDC job. But you see, here at Multimedia, we are used to this, and we are happy about it. Nonetheless, NDC is in power. They say Multimedia is opposition. MPP is in power. Then they say Multimedia is opposition. When they are all in opposition, they love us and they come here. Thank you very much. Gary's here. Okay, so let's begin with Dr. Draman. Doc, thank you very much for joining us. From the developments in the House, first, let's hear Speaker Bagwin, and then we'll take your comments. Let's hear Speaker Bagwin make the declaration.
In accordance with Standing Orders 59, adjourn the House indefinitely. That is sine die. I want to quote Standing Orders 59:1. It says, the Speaker may, in consultation with leadership, suspend a meeting of the House indefinitely or for a period determined by the Speaker, having regard to the public interest and the exigencies of the state of affairs in the country. Honorable members, I have consulted leadership, and I am exercising my discretion to decide to suspend the meeting of the House indefinitely. The House is accordingly adjourned sine die.
Thank you. So the Speaker adjourned the House, and we were told that there was going to be a lot of consultation. In fact, the majority leader and his group were told us that the Speaker had indicated that he was going to do a lot of consultations, and then after the consultation, he will come back to determine when the House will resume. Then just the next day, we have this document. It's dated the 22nd of October, 2024. Notice of meeting by request under Article 112, Clause 3 and Order 53 of the Standing Orders of Parliament. And it is seeking to compel the Speaker of Parliament to call the House back into action to transact very important business which has been listed on this order. Dr. Rashid Rahman, do you see this recall happening?
I'm saying, no, I do not see this recall happening. And if it does happen, I think we still have a very big problem on our hands. This issue is not a legal issue, and I think the earlier our parliamentarians and the two parties get it, the better. This is a political issue, and it requires a political solution. Our Constitution creates separate powers, and I think that you lawyers know that better than most of us. But, you know, in creating those separate powers, thinking that these separate powers will be equal to each other, and then the Constitution also has injected some checks and balances so that each power can check and balance the other. But, you know, it gets to a point where sometimes, you know, there are matters that have to be resolved politically. And I believe, I mean, looking at what is happening, this is one instance, because we've heard, I don't know whether that is true or not, but in the media right now, there is a lot that's going on about somebody trying to injunct this recall, another person going to the court and saying they need some interpretation whether the Supreme Court in the first place has.
So help me understand this, Doc. When you say you don't foresee the recall happening, what exactly do you mean? Because the terms of Article 112, Clause 3 are non-negotiable. We are operating a constitutional supremacy and not Speaker supremacy or President supremacy or judicial supremacy. So the Speaker is bound by the terms of the Constitution to recall the House within 7 days from the date on which he received the notice for recall.
Yes, so if you receive the notice for recall, and as we have realized, our parliamentarians and citizens under this eighth parliament are wont to always run to the court and try to use and invoke the rules. Somebody runs to the court and says, I'm injuncting this. I'm stopping the recall in East Tracts. Just like what we saw even before, decisions are made, because MPs will tell you that, you know, whatever happened on the day that the Speaker made those pronouncements would become firm and legal after they had reconvened and look at the official records and confirm the records. Even before that is done, you know, we have Parliament being stopped in East Tracts. And we have today, if you go into the chamber, day-to-day Parliament is recalled. Samson, I don't think that gridlock that we're going to see on Tuesday has been taken away. I am sure that both parties are going to insist that they are majority. The Right Honorable Speaker, you know, took the interest of the nation at heart when he stayed away, because many criticize him as not having said anything about the Supreme Court ruling. But if you hear him, I think the interest of the nation was, you know, what guided the decision he made. And the majority leader also did something that was good. He avoided, you know, what would have been some kind of fisticuffs within the House. So the point I'm making here, Samson, is that, these matters have not gone away. And so until we are sure, and I have been speaking to both sides, and I don't think that we have any negotiated solution yet.
So, Doc, when you say that, sorry for cutting, when you say that you don't foresee this happening, you are looking at the new suits that have come up, at least two of them.
Yes, indeed.
One by Benjamin Tete, both are actually by Benjamin Tete. There's a Benjamin Tete Yemo who filed a suit against the Speaker, that is yesterday at 1:02 p.m. And then he filed another one at 1:11 p.m. yesterday. It's against the Speaker, Andrew Asiamwa Adomako. That's what it is said. And then Cynthia Mamle Morrison, Kwejo Asante, and Peter Yao Kwache Aka. Those people who are involved. This is what you are looking at, and you are saying this could affect the recall?
Yes, indeed. I mean, that's what I'm looking at. So let me not go too much into the law because I'm not a student of law. I'm a student of politics. And so for me, I'm looking at it from the point of view of, I mean, if we have all these legal matters, and like I said at the beginning, this, I believe, in my knowledge of the workings of Parliament, is more a political issue than a legal issue. So if, all the negotiations that some of us are calling for have not happened, and we are going to go into the inch from their positions, maybe unless somebody coaxes them, unless they are forced, unless some negotiation takes place, then we might not achieve anything, even if the recall happens.
Okay, hold on for me. Dr. Theo Champong, do you share this view that this is possible, that the recall may not happen because of these new, suits? And I understand, and I have information that there are likely to be at least one more suit by Monday.
Samson, when the Speaker made a statement, he indicated, that there are issues, although it wasn't outright, right? Issues that need to be resolved within the legal processes, specifically the Supreme Court, and then now you have the High Court case, and then a few other cases that are likely to come. What that more or less means, I think, is that until those issues are more or less substantively dealt with, there may be a challenge with Parliament being able to recall within the timelines that we're looking at. So it's probably 50-50. My biggest concern in all of this is, what does this do in terms of course, parliamentary business and government business as well, given that there are some important bills that need to be passed.
Doc, we'll get to the items. We'll get to the items for the recall. But if this is what people believe, that simply filing series of suits has a potential to stop, the reconvening, what happens to the accusation that the judiciary is just doing the bidding of the executive? Does that not mean that they will simply dismiss these suits by Monday morning?
Oh, to the extent that it could lead to constitutional issues. Again, I'm not a lawyer, but I'm also a student or interested in these things. Then yes, the courts could sit as fast as they can, and the ones that they would dismiss on the basis of whatever legal arguments there are. The ones that they need to sit on and rule on, or the ones that, as you lawyers say, on the prima facie have some sort of evidence, that would go through the normal processes, and that could take a couple of days to be resolved. Even if we assume, right, that they are all dismissed, and there is still the Supreme Court, the third one that need to be resolved, that again would take some time. So you're looking at it's almost 5 or 6 days to the end of this month. And then you've got practically some days in November before the election, which then means that a number of key things probably may not, be resolved.
Okay.
But I think that the courts would act fast on this, definitely, to try and avert any sort of delay to the constitutional architecture.
All right, thank you. We'll come back to the issues that they are going to discuss if they eventually get the recall happening. Gary, the faith being expressed that the series of suits coming up are likely to stop the speaker from granting, a recall, suggests to me that the allegation that the judiciary is losing a lot of trust may not be true, because some people believe that there are fresh suits and those suits could determine the other way around against the majority.
You see, something, this issue, I'm happy that you commence it by stating the position of the law. You see, I always say that it is immaterial whether you belong to political party A or B. On matters of law, let the public know that this is the position of the law. So when you said it, and my brother Kofi Adam said he doesn't agree with you, I forgive him because he's not a lawyer. But when you indicated that what the Supreme Court has spoken and put a stay of execution on the order of the Speaker, the majority side remains as it were, the majority remains as it were. What has brought us to where we are now? In my view, my humble view, I think that
How do you start?
Right Honorable Speaker Bagbin will have saved the country all this brouhaha by simply staying his hands off and proceeding at the time when the writ of summons and the injunction application was served on Parliament.
On the 15th.
Yes.
Nothing was served on.
Before they took the decision.
You see,
It was ex parte.
you see,
They had not been served. That's
talking
correct.
There was
about-
no service
I
on
am-
Parliament.
You see,
There was no service on.
So it's okay.
You see, I have in my hand here a letter that was written on the 18th of October, 2024, under the hand of Mr. Ebenezer Ahuma Jetro. Is it called Jetro or Jetro?
Jethro.
Jetro? Okay. Now, this letter seeks to show clearly that the injunction process and the writ was served on the House.
Show us
During-
why. Show us why.
I should read the letter.
Show us why you.
Okay.
It shows that
Okay.
the House was served on the
Okay,
15th.
this letter is addressed to the registrar of the Supreme Court, Accra. Dear Registrar, writ of summons
Dated-
18th of October,
Okay.
2024.
A day after the Speaker made the declaration of the ruling.
The ruling. And you see, let's approach my with sober heads. That's what I'm saying, that it will have saved all of us the trouble.
So let's hear
Now,
it.
I am directed by the Right Honorable Aban Sumana Kingsford Babe, Speaker of Parliament, to return the attached processes which was left at the Legal Services Office of the Parliamentary Service by 3 bailiffs of the court on Wednesday, 16th October 2024. Attempts were made to set the same processes on Tuesday, 15th October 2024. Right Honorable Speaker notes that the attempted service is contrary to Article 117 of the Constitution and a circular issued by the Chief Justice, by Lady Cecilia Pamela C.A. Cranton J., as the Justice Secretary. Then they say, consequently, Right Honorable Speaker had directed the return of the attached processes for an necessary action. Signed, Ebenezer Ahuma Jeto. This letter now attached the processes, which was the injunction application, which was filed, which was seeking to hold the Speaker's hand to proceed to give a pronouncement on Article 97, okay, and it was returned back to the Judicial Service. Sometimes we should hasten slowly. You are just saying that because you were not served on the Monday as directed by the CJ in its party direction, you are returning the processes back to the judicial service. What stopped the speaker from just simply saying, yes, I'm now seeing the writ of summons with the accompanying claim and the injunction application, seeking to hold my hand to say that the very thing I want to proceed to comment on or to give a ruling on. So therefore, I'm holding my hands to abide by what the Supreme Court will say. In respect of the interpretation of Article 97, G and H, which is a new area altogether. Now, let's not forget, the Speaker has placed, the Speaker and the NDC side, they have placed a different meaning to the provision. The NDC side have also placed a different meaning to the provision. Speaker and NDC are simply saying that the filing of the nomination by these people at the EC amounted to a vacation of their seat. That's what they are saying, that the filing of the nomination at the EC amounted to a vacation of their seat. To the others, they understand of it. Majority side is also saying that the mere filing did not amount to a vacation of their seat. However, vacation of the seat will happen if and only if those members of parliament actually physically move from where they are to the minority side.
In parliament.
In parliament. So clearly, an issue of interpretation has what? Arisen, because they are put rival meanings.
So before we proceed on that, Article 117, it says civil or criminal processes coming from any court or place out of parliament shall not be served on or executed in relation to the speaker or a member or the clerk of parliament while he is on his way to, attending at, or returning from any proceedings of parliament.
Yes.
So was this service, Speaker Babin recognized this and said they attempted to throw it on the legal officers of the house whilst they were working.
You see, it is a difficulty of the implementation of the provision that you just cited. That is why Parliament and the Judicial Service now have to do what they call a party direction as to the mode by which, please, can I?
That services will be done on Mondays.
On Mondays.
Because Mondays they don't sit.
Good. Now, by this letter, what it means is that the Speaker of Parliament was seized with the facts of the writ, was seized with the facts of the injunction application, and he was fully aware that this is what Afenyo Makin was seeking to do, and yet proceeded to do what he did.
A while ago, you commended me for commencing on a note of being direct and plain about the law.
Yes.
In the face of Article 117, did the Speaker do the right thing, that they had not been served, or you will say they were served?
You see?
No, can we answer that?
No. They were served.
They were served?
They were served.
The Article 117 says, civil or criminal processes coming from any court or place out of parliament shall not be served on or executed in relation to the speaker or a member or the clerk to parliament while he is on his way to, attending at, returning from any proceedings of parliament.
You see something? That's why I'm saying that it is a difficulty of the implementation of 117. That is why they all agreed on what they call...
Let's pause on the difficulties for now. In the face of this provision of the law,
yes,
was there service by taking the processes, going into parliament whilst they are working and seeking to throw the processes on them?
Is it said they were working?
Yes, they were.
Parliament sat on Tuesday.
They were.
They were working.
Yeah, they were sitting.
On Wednesday, we sat.
You see, something. Let's get it very clear.
Was it service?
No, listen.
No, you.
So the service, hold on. Let's even assume that the service was even irregular. Okay, it was even irregular. Assuming it was even irregular. The contents of the writ and the injunction application has been brought to the notice of the Speaker. Is that not right?
Is that proper? Is that the way to do it?
I'm saying that, assuming the service was even irregular, let's say the service was even irregular. Let's agree that it was even irregular service. That you are looking at 117, and expecting that you must strictly apply the 117. The point I'm making is that the contents of what you want to do has been brought to your attention through the writ and the injunction that, look, please hold your hands on the interpretation of the Constitution. And let's wait for Supreme Court to give us interpretation. We all agree.
So
when
now,
it comes to interpretation,
let's move beyond that.
Okay.
Even though this is too plain, let's move beyond that. Do you think that if that were to be the standard, can you foresee the mischief? Parliament wants to do anything. By any morning, somebody goes there, throws documents at them, and says there's an injunction application. Not that a court has given an injunction, there's an injunction application, so stop. The next day, Parliament wants to do another business. Somebody is not happy about it. It goes to the court, files a process in the court. It has not been granted yet, comes to serve on them. What do you think?
You see, Samson, you and I know that when you file an injunction application, and the application is seeking to halt an activity, that activity is contained in the writ of summons and the claim. And you say, please stop. And the person proceeds to do the very thing that you are complaining about. That is service contempt of court.
That's not my question.
What is your question?
Do you foresee the problem with Parliament if what you are proposing works? Tomorrow, Parliament wants to do something. I don't want them to do it. I'm not happy about it. I go to the court, I issue a writ, I add an injunction application. It has not been heard, nothing. I go and throw it at them. The next day they want to do another thing. Somebody doesn't want it, goes file something, throws it at them. They should stop. They shouldn't work.
Oh, I don't think that you see, now you are going too far. You see, now you are going to absurdity. That, you know, people just issue frivolous applications and then we just go to a seven Parliament. I mean, now you're going too far. There is a matter where an issue of interpretation has arisen. And it's a matter that you and I know that 97 has not been interpreted before. It's a matter that the two parties, including the speaker on the NDC on one side.
I don't want us to talk about that. I've seen you are just evading my question.
I'm not evading your question. I'm not evading your question. I am saying that, you are going into an absurd situation. What you are saying, it's an absurd situation. That, anytime one people don't do anything, then you go and hold them. That's an absurd situation.
So you appreciate the purpose of the arrangement between the Parliament and the judiciary?
I do.
That if you have to serve things, serve them all.
I do, 100%, I do. The only point I'm making here, for all of you to understand, is that the very thing that they were seeking to halt, he was aware. And he gave his ruling, which he said is a comment, his ruling on the matter, and now it's confusion. People say they have stayed it. He came to Parliament, they didn't indicate that because the Supreme Court has stayed the ruling, that is the reason why I'm adjourning. Rather, came under a different order, they said, well, in the public interest, and, I'm now adjourning the matter. Okay. I sincerely believe that on the matter of the law, as complained about, if a member of Parliament who is there for 4 years, certain, has not physically moved from his side, that is NDC side, to MPP side, in Parliament, I do not think that you can say that member of Parliament indeed has crossed carpet. Cross carpet simply means that, it means you have changed the character of how you come into Parliament by physically moving from where you are to a different position in Parliament, not by your intention. How are you going to rule intentions? Your future intentions. This is what is future intentions. So for me, I
wish
think that
we don't relitigate Article 97(1) because we have spent time to educate our listeners on it and our viewers on it last week. But since you are still bringing it up, let's read it to our viewers one more time.
Very well.
Article 97(1) says, a member of Parliament shall vacate his seat in Parliament. Shall vacate his seat in Parliament.
Yes.
Correct?
Yes.
That is mandatory.
That's correct.
You have no option in it.
Oh, you have no at all.
It says you shall vacate your seat in Parliament if these things happen. Parliament is dissolved. If the person is elected as a speaker, if the person is absent without permission from the speaker as required.
Blah, blah, blah. So let's go to the contentious ones.
If the person is expelled from parliament.
Okay.
Then when you come to F, it says if the person resigns as a parliamentarian.
No, there's no question about that.
G,
and I'm expecting
if he leaves
parliament tomorrow.
G, if he leaves the party of which he was a member at the time of his election to parliament to join another party.
Good. Now,
or seeks to remain in parliament as an independent member.
Yes, let's break it down.
If you leave your party.
Let's break it down.
Okay.
Let's break it down. So that you see, as you said, for the education of our
right.
viewers. If he leaves the party
that brought him to parliament.
How do you leave a political party?
Yes.
You leave a political party by writing a letter to indicate to the party that you, so and so and so and so, you're a member and you have left the political party.
You must write a letter.
You must indicate that you have left the party.
Wait.
This constitution.
Hold on. Adam, hold on. Yes. Please hold on. Go ahead. Yes.
The other one is what? The second leg is what?
The second leg is, or you seek to remain in parliament as an independent member.
These members whose conduct is now brought.
The Bold Safety Team, by your side on every ride.
Parliament, the answer is no.
They want to become next parliament.
In the next parliament, they expect a future intention that in future, 2025.
So you know their intention.
That's an intention. They expect their intention.
You were saying it's difficult to find the intention.
No. I'm saying
if they have not physically moved in parliament from where they sit to join the other party.
No. You see,
if you declare yourself as independent,
yes,
in parliament, where do you move and go and sit?
Independent, when they come, they also have to join the one side. Either you want to join the majority side or join the minority side.
So, Esiama, where should he have moved to?
Esiama should have moved to the minority side. Let me decide.
Okay. That's the only time that this law applies.
You must physically move. You see, you must physically move.
Okay.
Because if you say that you have declared an intention to go for future elections as an independent candidate, or you want to now go, join a political party in future, but you have not resigned from your political party.
What Ghanaians are asking you now is,
yes,
Marco Kwe did this. You were happy about it. Why now?
You see, Mr. Marco did it. I was happy about it. I didn't comment on what Marco did. So why do you say I was happy about it? I didn't comment about it. Did you hear me comment about what Marco did? I didn't comment.
Did he do right?
In my view, the question of interpretation is the exclusive preserve of the Supreme Court.
Did Michael Kwe do right?
I will not say to pass a judgment on Michael Kwe. He was my professor in political science. I'm not just sitting here.
So you don't know if he did right or wrong?
I am saying that what Michael Kwe did at that time, by seeking to interpret the Constitution in Parliament, is a preserve of the Supreme Court.
Okay. So here, you said you need to write a letter. This is a letter written by Justin Kodua Frimpong on the November 20, 2023.
To who?
Let me read and you get to understand. It says, it's headed Forfeiture of Membership pursuant to the provisions of Article 391 of the New Patriotic Party Constitution. The leadership of the New Patriotic Party has taken notice of recent activities of Hobson, Adoye, Yabuabeng Asamoah, Nana Ohene Nto, and Boniface Abubakar Sadiq, which includes publicly endorsing the candidature of a person other than the duly elected presidential candidate of the party, His Excellency Dr. Mahmoud Bawumia, in spite of their flagrant breach of the party's constitution. Then it quotes blah, blah, blah. The aforementioned men still hold themselves out as members of the NPP. For the avoidance of doubt, then they refer to the particular article and then come to say, in line with these constitutional provisions, it is the view of the NPP that Hobson Adoye, Nana Ohene Nto, Boniface Abubakar Sadiq, and Yabuabeng Asamoah have automatically forfeited. Automatically forfeited is in caps. Their membership of the party they are therefore no longer members of the party.
Thank you. I'm happy that you quoted NPP constitution. But you didn't quote national constitution.
No, you said you need to write a letter
I'm saying
to
that,
show that you have left the party.
no.
Did these people write letters to the party?
Well, this is a situation where the General Secretary said he has taken notice of the activities of these persons, and so therefore the membership is forfeited.
And they did this on your advice because that's your job.
This is the operation of the MPP constitution. Okay?
It says
MPP constitution. Oh, Sammy, can I?
It says what? The constitution says what?
Can I finish?
Go ahead.
MPP constitution is subservient to the national constitution.
Okay.
This thing we are talking about here is an issue of national constitution.
So does the MPP constitution require you to send in a resignation or a letter before you are deemed by the MPP as having forfeited your membership?
Well, sometimes your activities can show that you must dismiss you. You can even be dismissed from the party. Yes.
Okay.
From the party. I'm saying that in this instance, even though the conduct of these MPs, to me,
I'm holding NDC's constitution.
It's impugn.
This is a copy. I'm holding MPP's constitution.
Is it amended one or this is the old one you are
this,
holding?
This is the amended. So
This
actually,
amended
this one is not Article 3. This one you
So,
find
but
you find in Article 9.
Hold on.
Forfeiture of membership. I want to read something to you.
Hold on.
I want to read something to you. Forfeiture of membership. It says a member of the party who stands as an independent candidate against the officially elected member of the party, or who joins or declares. Once you declare, you are caught. Who joins or declares his or her support for another political party or for an independent candidate when the party has sponsored a candidate in a general or by-election, automatically forfeits his or her membership to the party.
Yes, this is the MPP constitution, and I agree with it. Now go to the area where it says a member shall not lose his right for membership unless he has been heard. In the constitution of the MPP. It's there.
Where? Boniface, Abubakar, Sadiq, all these people, were they heard before you issued this letter telling them that they have automatically left the party because they have declared for Alan Chamating?
You see something. A constitution should be read as a whole. You don't pick and choose the portion that favors you and use it. No. You read as a whole. I'm saying that this constitution of MPP, if you read it as a whole, you ought to hear a person before you take certain actions against the person.
When the party wrote to Michael Quay, did the party hear Mr. Esiama before they wrote to Michael Quay?
Esiama, well, that's one that I cannot.
They did not. They did not,
right?
Yeah.
Okay, I can confirm that, but I can't be sure. But the bottom line is that let's understand something. This is the first time in this party's history, as far as I'm concerned, that we have been doing primaries in the party, and post the primaries, you have litigation in court, several cases in court, sometimes 46 cases, sometimes 30 cases. We have the case of the country resolving cases.
Yeah.
In fact, this year was the only time that the party went for primaries. There was only one case in court, of which you were involved in that matter. Okay?
Yeah.
Only one case. Only one case. Everybody who took part in these primaries was given the full opportunity to take part freely. You will lose, you will win, you realize that you have actually participated fully without any inhibition at all. It's the first time. And that case, that even happened enough. That was the only matter that became a sort of matter of a court suit. So for me, if you go into a primaries and you lose, and then you decide, having lost the elections, you want to go as an independent candidate against the party's nominated candidate, to me it's an unfair decision against the party.
Okay, I have one more question
it is
for
not
you.
Right.
So I need us.
It is very, very wrong.
I need us.
But that doesn't mean that they have also lost their right to stay in parliament.
I need us.
But they have not said they have cross carpet.
I need us
physically in parliament.
I need us to move on. But because you brought in the Walewale case, let me tell you one interesting thing. Why some people have issues with the courts. In the Walewale case, the judge came out and said, this person case has won. This person has lost. He didn't read anything. And he said he did this on Monday, September 2. And he said that the judgment will be ready September 12th. As we speak, we have written to the court many times. The judgment is not ready. This is some of the things that dips people's hope in the courts. Now the question I'm asking you here is
that could be an isolated case.
Isolated.
Which reasonably.
Okay.
I will not agree that you give a date for judgment and then you don't deliver the judgment. Maybe there may be a reason for that, but I think communicate why the judgment is not ready. Okay. That notwithstanding, I think there has been elections there, and your candidate has still won.
Well, this has just also happened. I think the PPP case, the judge dismissed their case. There's no judgment for them.
Which of the cases?
I think PPP. They've been dismissed. They've been disqualified from the elections.
Yeah, the
standing.
One.
Yeah. Okay, but this is the question, and I need us to move on.
Right.
This is the question. It's about whether you think the approach to compel the speaker to call Parliament will work.
You see, it's two things. It will work if the Speaker of Parliament is willing and ready to accept that in this country there's something called rule of law. Rule of law. And there's something called constitutional supremacy, not parliamentary supremacy. And the only body that gives orders to this matter, the Supreme Court, giving these orders, which the failure to obey or amount to a high crime, I think the Speaker, if he's going to obey that order, pending the determination of the suit, should obey the order.
The order is not that you should call Parliament. That's not it.
No. But when you call Parliament, there's a grey line here. Where do majority sit? Where do the minority sit? At my last check, NDC is saying that they are the majority.
So they are sitting on the right-hand side of the Speaker?
Yes, and to the extent that even when Hazard was even being corrected and all that, Esosu made a point that the Speaker, he think that was referring to a minority, not majority. It was so corrected. And I was listening to it on your network.
It was not corrected. The Speaker said, let the department check the records and let it reflect what exactly
it was. Very well. So now when the Parliament is recalled, and the last time we saw them go to sit at the majority side, and you see Honorable Fanyamaki also came, the came also, they want to sit at the same place. Look at the chaos that will have, engulfed Parliament. Should these honorable men and women go to Parliament and they are struggling for the same place? I think Speaker should be bold and tell all of them that I'm the Speaker of Parliament. This is my chamber. This is my house. I have to regulate all of you and what you are doing. The court of Ghana, Supreme Court for that matter, has stayed my ruling. And so, I am ordering that majority be at where you are or where you were, minority be at where you were, so that we can conduct business until the court determine the matter. For all you know, the court may be able to deal with this matter in a very efficacious, quick manner, and this matter will come to an end. If the court comes to a conclusion, the Speaker was right.
No, my issue now is, and the question is about this. He's being compelled to call the House. Many, including Dr. Rashid Rahman, is saying the solution is not a legal solution. It is rather sitting together to talk. You know the Speaker can recall the House today and adjourn it the same way he did.
Yes, I agree with you.
And then you force him to call again. He can call again and adjourn the next day, even though that will be that will be irrational and abuse of discretion.
I think the issue to me is both legal and political. The tempest must come down.
Okay.
I think the tempest must come down. We must find a diplomatic approach to be high diplomatic in both minority and minority being NDG side, majority being MPP side. They should find a way to navigate these steamy waters. You see, some of these things.
So why do you go on with a compelling process just a day after he calls he adjourns indefinitely, rather than seeking to talk with him to see if you can agree?
You see, I'm saying, you look at the quick manner with which the minority side were trying to form committees, the quick manner which they were trying to now
repeal betting tax, repeal e-levy.
When they say betting tax, I'm the board chairman for NLA, and I was board chairman for gaming commission. So,
okay.
For me, I think the speed with which they were trying to change things they necessarily require that Afenyo do something about it. And for me, I think the Supreme Court saved the country by bringing the status quo to stay. Save the country. That's why I see they save the country, because if they have taken these steps in that quick manner and started to change a lot of things, look, something. This is a serious governance matter.
So why didn't they go to the House
matter
that day so that there will be sufficient numbers to take decision? Because they didn't go there, you didn't have half of the members. That's why the Speaker adjourned.
Yes.
If they had gone in there, you would have had half of the members at least, so Parliament can go on with its business.
I think that, you see, even before Parliament is recalled, there has to be serious discussions, majority side leadership with the Speaker using cool heads.
Okay. Kofi, well, you guys insist that you are still in the majority because the 4 members who were kicked out still are still kicked out.
Well, Samson, thank you so much for the opportunity, and I know I would equally get the time to navigate.
Not necessarily. Not
all
necessarily.
the areas.
I had a number of questions for him. I may not have the same number of questions for you.
All the areas. Well, I want you to ask the same number of questions because they are all areas that I equally also have a position on.
Let's start.
So, first and foremost, the 1992 Constitution is very clear. And if I take you to Chapter 1, Article 3, it says Parliament shall have no power to enact a law establishing a one-party state.
That's correct.
It means the Constitution jealously protects multi-party democratic dispensation. So the Constitution doesn't want a situation where you go through an election and one party wins so many seats and decides to make a law that necessarily abolish other parties or force them and to create a one-party situation. Samson, the same Constitution is so clear that it doesn't want political parties to just think that their constitution are only for them and not public documents. So if you go to Article 55(7), the very first requirement for an organization to register with the Electoral Commission is its constitution. If you read 55(7), it says, for purposes of registering a prospective political party shall furnish the Electoral Commission with a copy of its constitution. That's the first thing that is mentioned.
Right.
So a party's constitution is not their private bona fide that they think they can handle to do with it any way and anyhow. The Constitution of the Republic makes provision for you to become a political party. You must submit, the first document asks of you is your constitution. So what you put in there becomes applicable in courts and in any situation where somebody has been given the mandate to interpret. And on a daily basis, nobody should fool himself that only Supreme Court interprets our laws. Every day when you have a mandate, the executive is interpreting laws by its programs that they do. Parliament is interpreting laws by its program that they do. It is only when there is an issue of question at a lower court, then of interpretation, understanding, it is referred to the Supreme Court.
That's not the only point.
Well,
when also, as an individual, I think that the meaning or the interpretation somebody has taken is not good, and that there is an ambiguity.
Exactly.
I can go to the court to determine whether there's ambiguity or it's clear.
You are right. So what I'm saying is that an institution that is implementing its understanding cannot say, I am referring to Supreme Court to interpret before I will implement.
Excellent.
And nobody is to pre-jump an institution and read into its mind like you are going to do this, therefore I'm going to court to seek interpretation. Afenyo Maki, the minority leader now, went to Supreme Court even before the matter was raised on the floor of the House. He went to Supreme Court.
Is that a decision?
Yes. He went to court. He went to court even before the statement was made under Order 93.
He went to court on the 15th.
Yes.
The statement was made on the 7th.
The statement was made on the 15th afternoon. He went to court in the morning.
Okay.
And that was when he saw
the statement was made on the 17th.
On the 15th Tuesday.
Correct.
15th Tuesday. That was when the then minority leader, now majority leader, made the statement.
So on the day the Speaker was going to deliver his decision, 2 days after that day,
exactly,
he brought the process.
Then he brought the process. So he went to court even before a statement was made on the floor of the House. And like you said, it is only when an action is being taken and clear processes have been established to take a particular action that one could decide that based on these steps that is being taken, I am going to Supreme Court to seek interpretation.
But in the case, can I clarify?
No, wait.
Let him go. You can.
I wanted to clarify a lot of things. Something asked me to wait. At the point I was even sleeping. I decided to sleep. So this was what happened. But you see, Parliament feels like in its workings, nobody, no institution should stop Parliament from the performance of what? Its functions.
In fact, this is the jurisprudence that people can use our own laws to show that until Parliament has done an act, you cannot question it. When they are done with it, then you can go and question it.
For example, not too long ago, this narcotics law, Parliament went through the processes
and passed it.
Somebody thought that one of the processes did not meet the constitutional threshold. So he went to court, went to Supreme Court, and the Supreme Court ruled on that aspect.
They struck it down.
They struck it down. And that they have a right to do. We have acted, we have finished. And then someone questions it. That is allowed. On this occasion, well, like I said, Afenyo King went to Supreme Court earlier than I thought he should. The action was taken even before the Supreme Court sat on his matter. At the time the Supreme Court was sitting on his matter, Parliament have already taken a decision. And what he sought to injunct Parliament from performing, Parliament has already performed it. And so, what is the result of that injunction?
It's not an injunction. It's a stay of execution.
Of course, stay of execution.
So stay of execution says you have done something. You are going to implement it. Hold on, don't implement.
And I'm saying that we have already implemented it.
No, Barata, you have not implemented it.
We have implemented it. On the 15th, when the decision was taken, you have implemented it.
How?
Because the decision has been taken. Look, when Parliament decides on something, a matter such as this, if we were within maybe more than 3 months, and there was supposed to be further actions of the clerk writing to electoral commission, then we could stay those processes. But we are now within the 3 months period where there will be no need for a by-election. So you don't move to the other stages that the court is seeking to stay. In the understanding of Mr. Speaker, when we met again on Tuesday the 22nd, Parliament's decision, and not Speaker's decision, is Parliament's decision. When the Speaker makes, because the process started with a statement, Honorable Haruna wanted to come through a petition, and Honorable Atufosin came through a statement. And that statement was commented upon by many persons. And those who were specifically mentioned had a right to also comment on the statement. They chose to stay off from commenting. At least I knew the independent member of Parliament, per parliamentary records, was present. He did not comment because he knows that the statement that was made was right. And he at least has suffered it even before. So he did not comment. He did not rise for the speaker to say that I'm not recognizing you. He did not. So all those who are talking about fair hearing, they were not heard and so on, nobody stopped them from commenting. None of them went on his or her feet for the speaker to say, no, you will not, I will not allow you to comment. So now the speaker rules, and as far as we are concerned, that ruling stays until Parliament itself decide through a process. Because Parliament takes act with decisions. And that is why the speaker said, we have the numbers to do business, because that comes under Article 102, which is 1/3 of the numbers of what? Members of Parliament. To be able to do that one, you need about 92, 93 thereabout. My mathematics, we don't have half human beings, so let's take it. Maybe if it's a member that is presiding is a deputy speaker, then maybe 92. But if the one presiding is Mr. Speaker himself, then I think 93 is what I think. So between 92 and 93.
Speaker is not counted.
So he's not counted, but the deputy speakers are counted.
Right.
They are counted because they are members of what? Parliament. If
this
they are
92,
presiding,
that's this Parliament and your other parliaments, hardly you struggle to get that 92.
well,
Can you imagine this kind of Parliament?
So
And the day this decision was made, how many MPP MPs were in the House?
which of
there were about 7 or so.
the 17th?
Yes.
The Thursday when the speaker
That's right. That's right.
Yeah, there were not many of them. There were not many of them. The truth is that they are struggling to have their members attend to business of the House. That's the fact.
They are campaigning.
They are campaigning. Their General Secretary himself have actually written a release to them that they should be in their constituencies and what have you. So that has been their focus.
Okay, so now let's come to where we are.
So where we are is that
They are
the 17th.
They are written to compel the Speaker to recall the House.
And we know that the decision of Parliament on the 17th stays until Parliament itself, through processes.
So you mean even when Speaker recalls the House, the NDC will be majority?
The NDC will be majority.
Because the 4 people who have been declared are still off.
Are off as far as Parliament is concerned.
That will be disobedience of the court order.
We are not disobeying the court's order. What the court is asking us to do, we already have done it. What the court is asking us to do has already happened, and so we cannot stay it. We can only go through a decision process.
The Constitution says that if the Supreme Court make orders and you do not comply by those orders, you are committing high crime. High crime can attract up to 10 years in prison. And after the service of the 10 years in prison, you are also prohibited from holding public office for another 10 years. If it is the president or the vice president who are caught in disobeying Supreme Court orders, that is grounds for impeachment. Do you understand how serious this is?
Parliament has already taken a decision.
Kofi.
Supreme Court spoke when? Supreme Court gave its so-called orders, not declarations.
So-called orders.
No, the orders, not declaration. Allow me to.
Kofi.
Not declarations.
You're my brother.
They gave the orders when? On the 18th.
On the 18th.
Parliament took a decision on the 17th. As far as Parliament is concerned,
And the court says stay.
the decision has been gavelled. The decision of Parliament has been gavelled. And so it is only Parliament, so properly constituted under Article 104, that can walk back its processes. And that is the understanding of Parliament. That is
the horses had bolted before the Supreme Court.
Before the Supreme Court.
So now listen, the principle of stay in law actually works in that way. You have done something, but you are now going to implement it. Then the court will say, don't implement until further notice. Well, this is what it is.
And I'm saying
so today, if Parliament is called, is recalled, and those 4 MPs decide to come to the House, and the marshals prevent them, or they come into the House and they are being asked to leave, or they try to rise and they are being stopped, or they try to speak and they are being disallowed, that would be disobedience of the orders of the court. Do you appreciate
that is your interpretation, as we all do.
That is a law. That is a law.
And I'm saying that allow us. There are other lawyers who have also spoken. There are MPs who are also speaking. And I'm saying that our understanding and what we are using is that we have already decided.
So the recall will not happen.
Well, as for the recall, I'm now coming to the recall. The recall, when it happens, because constitutionally, the hands of the speaker is in a way tied. Because it says when the 15% petitions, he shall, within 7 days after receipt of the petition, determine a date that should not be more than.
The petition was on 22nd. So next week.
Well, it was dated 22nd, but I don't know when
it was
served on the speaker. Right. I doubt if it was served on the same 22nd, though dated 22nd.
All right.
So he may recall. But the question now is the minority MPP ready to abide by Parliament's decision on the 17th? If they are ready, then I believe that the House may be properly constituted to take a decision. But if they are not ready and they will stay in their offices, we may not have the numbers to do any business. And if they go and occupy the majority side, we, the NDC, will decide to stay out, and they will also not have the numbers to do any business. These are very clear. Again, there are already some legal actions that have been taken that stays the hands, and that person is coming under Article 99. And many lawyers who have spoken have said the right forum was not the Supreme Court, and that it should have been the High Court.
That's right.
If a question arises as to a vacancy, the right forum is the High Court.
The Constitution, Article 99, is very clear on that.
And that the forum should have been the High Court. And when the High Court feels there is any issue of interpretation, then maybe they can refer that to the Supreme Court.
It's a sound argument, but it's only one part. Yeah. If a person believes that the terms of the Constitution in the manner they have been implemented is not right, they still can go to the Supreme Court to seek an interpretation.
Well, but Samson, where a provision is clear, there's a clear provision that it matters to do with vacancy. When a question arises, this is the forum.
Okay.
Where there is clarity, I don't think that we should be leaving it for people to decide that, even though the Constitution, 1992 Constitution, not court practice or anything.
You're right.
Makes provision, clear provision. We should not be leaving it for people to decide, no, I want to go to this forum because I feel they are the ones that are mandated to interpret. So somebody has gone to the right forum, seeking to support the decision of the speaker and staying his hands from allowing them in. And
what do you think that after the Supreme Court has said we have issued a stay, and I appreciate your argument, which says we have already done the thing, there's nothing to implement, so you can't stay us. I appreciate that argument. And some people have asked me the question, when Domolevo situation happened and the court gave its judgment, by the time the court gave its judgment, things had already finished. Could there have been a stay of the whatever it is? So the issue now, Kofi, is if Parliament is recalled, you, from what you are saying, even if the NDC don't go to Parliament, the MPP will still not have half.
They won't. Not in this state of the MPP that we have.
So they cannot be decision taking.
Look, let me tell you, no amount of whipping will get MPP, assuming even that Parliament decides that, we want to allow the status quo as it was before 17th to stay. No amount of whipping will get MPP their 137.
This is MPP that has flown people from abroad.
I am telling you that
on private jets just to come and attend Parliament. I am telling you that this is MPP that has wheeled people in ambulances to the Parliament.
Samson, take it from me. Have you seen the number of MPP persons who are commenting on this matter? MPs. Have you observed? Have you observed the number of MPP persons?
They cannot be bothered.
They cannot be bothered. Did you see the number of them who were following their leader? Did you see?
Yeah.
Look, if Parliament today even decides that we are giving you the status quo as it was before 17th, the MPP will not be able to get 100 of
the cases, the new cases you are referring to. Do you sincerely believe that a high court will take a decision different from what the Supreme Court has done?
Well,
that they are going to say, give us an injunction against the Speaker recalling, and then Supreme Court has already said, I've stayed your whatever, so let the process move on. Do you think
if the courts are minded to apply the law and the Constitution, and not say be looking up that some bosses somewhere have spoken, and so therefore I should just follow that, I think that the High Court can do so. I seriously think that. But I'm also worried when there is so much clarity in the MPP's constitution about forfeiture of membership, then you get them come to sit and make all kinds of arguments that do not find space or comfort in their own constitution.
Their constitution does not actually require you to have filed.
To have filed,
it says once you declare, you have lost your membership.
It says, so we were even waiting for a document of a notice of polls, which is gazetted document to rely on. We did not base it on just mere declarations. We waited for a document, a notice of polls to act. Your constitution itself, that has been accepted, says once you declare, once you campaign for any other person against the legally elected party's candidate, you forfeit your membership. And now you come back without any provision that says that you'll have to go through their National Council or Council of Elders and whatever. If there was any provision...
Gary hasn't said that. Some other people...
Yes, some other people, yes. I'm not saying that Gary have said it. But you know, these matters, we are speaking to what many have heard also.
That's right.
So that is why I'm bringing that. I'm not suggesting that Gary have said so on this platform. So clearly, I think that the MPP should just obey their own constitution as submitted to the Electoral Commission under Article 55(7). And as enshrined in their own, those persons have lost their membership. And for the independent, they say once you join a political party, in the case of the independent, it's so clear that if you are elected an independent and you join a political party, so he has joined a political party, and MPs don't only work in Parliament, in chamber. The MPs equally have other responsibilities in the constituencies and elsewhere.
Do you understand that this declaration affects these MPs, their gratuities, like they will be entitled to ex gratia, all of that is lost?
Of course,
it's been terminated. And then
normally I think it's a certain amount.
The thing that the presidents, they normally do late, the constitution says they should do at the beginning of their office, but they don't. Their own emoluments. They wait until they're about to go out and then they bring it to Parliament. You approve their salaries and their gratuities. Can you imagine that you, the minority, become majority and you are now going to approve Akufo-Addo's gratuities?
Well, that is the practice. That is the practice that have happened, and usually it is when we return after elections that we deal with those Article 71 and related matters. So I clearly know that there's work to be done. We are ready, we are prepared. This is a side, something that have cooperated to run government business. Even when we were in court, that's my last point. Even when, as a party, we were in court against the 2020 elections, we sought to approve the budget that was read by Honorable Chairman Sabonsu and not the finance minister, because at that time they didn't have one. We approved all the nominees. If we were there to frustrate government business, that was when we would have frustrated that government business. So we are not doing this to frustrate any business. We are doing it because the law says so. And we must all be law abiding. They should advise their people appropriately and rightly for them to return to the seats where they are supposed to sit. They are in the minority now until Parliament says otherwise.
Okay, thank you very much. I'm taking a break at this point, but a colleague sends me a message and he says, Samson, it is not any disobedience with any order of the Supreme Court that constitutes a high crime. The only order that is the subject of high crime is a consequential order under Clause 2, Article 2 of the Constitution. That's a remedial order after declaring a conduct unconstitutional. The Supreme Court's order for stay of execution is not a consequential order, please. Its disobedience may, at worst, be contempt of court. But I read that provision to you. This is what it says. And tell me if it says it's consequential orders. It says, failure to obey or carry out the terms of an order or direction made or given under Clause 2 of this article. What is Clause 2? Clause 2 says the Supreme Court shall, for the purposes of a declaration under Clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect to enabling effect to be given to the declaration so made. Well, these are legal issues. We'll continue to banter over them. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. My outfit is by Konati Clothing. You can call them 0244 676732. You can find them at Adenta Shopping Center, Adenta Down. Thank you. And going to go through just a couple of your messages, and then I'll go to Dr. Draman and Dr. Theo Champong on the business that is slated to be done if Parliament is recalled. And having heard from the two the politician and the lawyer politician, whether they come, yes, they come to the view that it's not going to happen. It's never going to happen. Even if Parliament were recalled, the NPP cannot get as it were, half of the House to be able to take a decision. Right. So, okay. Right. So, Ala Suleiman says that, okay. All right. Thank you very much. Thanks for those messages. I'm actually supposed to be in Kumasi at this moment at Asanteman Senior High School, my alma mater, where there is a grand debate going on to crown our 70th anniversary celebration. The Otumfuo himself in attendance. The president is supposed to be there. The education minister is supposed to be there. And I actually supposed to have a role to play there. Let's see how it works. Right. So, Dr. Theo Champong, let's go to the issues that are tabled. Important tax waivers. Oh, no. Yeah, Dr. Druman, the matters that are being tabled, initially there were just a handful of them, but we are being told about an addendum that balloons the matters to quite a lot, over a dozen issues that the majority would like to be done. What do you say?
Thank you very much, Samson. Maybe before I get to that, let me just make a very brief comment on the matter that you raised earlier about the mischief, using the law to cause mischief. And I think you were making a hypothetical kind of projection. I want to say that I have lived through to see this happen in another country, and that's why I think that we ought to be very careful. I have seen this happen in Malawi, where people have actually used the law to create a lot of mischief to prevent Parliament from doing its work. At a time when a friend of mine, an accomplished constitutional lawyer and former finance minister of Malawi, was Speaker of Parliament. So this is possible. And also, Samson, can you imagine maybe for one moment, on 7th December, we wake up after the election, somebody runs to the court and says, we are stopping the Electoral Commission from doing what it has to do, and then the court has to come in and so on. So mischief is real, and we have to be very careful. Otherwise, this country could be plunged into some serious difficulties. Now, let me come to...
And before that, you bring this up. Do you think that by the parliamentarians themselves resorting to the court and seeking to rely on the court to stop Parliament from doing its business, they are helping one arm of the government to weaken Parliament itself?
Yes, indeed, Samson. You know, our kind of democratic practice is supposed to stand on three legs, and three equal strong legs. But if you look at it right now, the wobbly one, the weak leg, is Parliament. And I think the Honorable Kofi Adam is there, he can confirm that. And, you know, the penchant that we see now, particularly in this 8th Parliament, every little issue, sometimes maybe we might get to a day when even somebody coughs in Parliament, somebody will run to the Supreme Court and say, can you interpret this to tell us whether this is parliamentary or unparliamentary? You know, if they are doing this, they are weakening the very institution that they all belong to.
But there's one thing too that you can be assured of. If you go to the Supreme Court and you invoke their interpretive jurisdiction and the matter does not call for interpretation, they'll throw you out.
Well, they will. But, you know, something in between, it just stalls parliamentary business.
Okay.
Yeah, so that is the side that we need to keep in mind.
Do you
because all these unnecessary? I mean, we are seeing a lot of suits right now.
Yeah.
You know, they are going to delay what is looking like some urgent business that needs to be carried out.
Do you share Kofi Adams' his fears that even if the House was called, the MPP, if they were left alone to go into the House, they can't marshal half of the members of Parliament to be there to do the key business? There are two Supreme Court judge nominees pending approval. There is $350 million tax waivers that are also pending approval. You have the Financial Stability Fund, $250 million of money that also has to be approved by Parliament. There is the business of revoking mining in forest reserves, you know, clause of the legislation that has become very contentious, among others. Parliament will not be able to get 138 members to deal with such businesses.
I don't know maybe the basis on which Honorable Kofi Adam is making his projection. But let me stay with the facts, Samson. I think over the years, and particularly in this 8th Parliament, we've seen your cameras go into the House and show us a House that is mostly half empty. But over the years, they've managed to do business because they are masters of their own rules. When we start sticking to legalities, then heads will start being counted. And that is where we get into trouble with government business.
So they have been managing breaching the law, because, for example, the 92 members you need to commence business, many times they don't have the 92, but you need someone to rise up to raise it. If somebody doesn't raise it, then they will pass the process through. Indeed. So that's the point I'm making. So where it becomes a legal issue rather than a political issue that needs negotiation and compromise, then people will stick to legality and nothing gets done. And that's why I was saying right from the beginning, this, whilst it is legal, I think it's more political than legal. And something, let me come back to this issue about the business that needs to be done. There are some businesses that maybe might just have come up because they are businesses of the moment. So i.e. the LI about Galamsey and so on. But I think over the years, NDC, MPP, what we have seen is that both parties have the tendency of backloading most of these important businesses. At the time when Parliament is about to rise, then they get MPs to sit till midnight when they cannot think properly and straight, and get them to approve, important business that commits this country and sometimes commits future generations. And I think that this is a very important lesson that we all need to learn. That I think if there are important businesses,
I mean, let the government bring these businesses and let our parliamentarians do the needful, do the proper scrutiny that is needed, so that at least these can pass.
Right.
Otherwise, I mean, we know year in, year out, our country has been subjected to all kinds of judgment debts and so on. And the question many are asking, where was the scrutiny of Parliament and so on?
All right. Kofi, do you think that the business tabled, supposing, because you are outright firm that you can't even get a quorum to do business or to take decisions, do you think that if that happened, there were consensus building everything and that happened, the things that have to be done, the tax exemptions, the Ghana Financial Stability Fund, the Environmental Protection Agency Bill 2024, Social Protection Bill 2023, Customs Amendment, Budget Bill 2023, Ghana Boundary Commission Bill 2023, Interstate Succession Law, you think all of these things will happen?
No, not at all.
Why not?
Looking at the number of days that we have left, I don't think that we'll be able to do all this.
Explain that. Number of days left.
Well, some of the bills are yet to even go through the processes of committees submitting their report and the principles behind to be debated. Then it will now go through consideration, second reading. Those that maybe have reached third reading stage, we could easily pass them through. And for example, for the LI 2462, the Environmental Protection, that is Mining in Forest Reserve Regulation 2022, we are of the opinion that this should just come by a statement and through a resolution, we get it kicked out. That's our position.
The government has so far not submitted anything.
Government has not submitted anything. Government position was that, through the Attorney General's advice, was that it must lay in Parliament for 21 sitting days. And so the understanding we got was that if this is what government want to do, then on the 15th, the first day of our sitting for this particular meeting, you introduce it, so that we will see if we can urge Parliament.
15th of October.
15th of October.
And it has not been laid.
It has not been laid. So we were thinking that even when it comes on the 15th, Parliament must be encouraged to sit on Mondays and possibly even add some Saturdays. But it hasn't come.
When are you rising?
Well, if we had continued, we were supposed to have gone somewhere around second week in November. Second week in November. So we're just going to do about some 5 weeks, and that should be all. But now that this stalemate has come in, we may only come and possibly approve the expenditure in anticipation.
So if a bill was put today, it won't meet the time?
It won't meet the time. I don't think we will get the time. Because already now we have taken a decision that we will sit only Tuesdays, Wednesdays, and Thursdays. And Thursdays will be decision days. So even Friday, which used to be a normal sitting day.
But as you noted, sometimes you make sacrifices. You sit Saturdays and Sundays,
well,
so you can make up the time.
That was why, first and foremost, we thought that we should not go through the route of laying this bill for 21 sitting days. We thought that Parliament...
But your members, Okujeto, Alasan Suini, and Sevia Susu are trying to use a private members bill.
Exactly.
Which will also not work.
Well, because government that promised us even before we came, we thought we'll bring something on the 15th and have brought nothing. So the realization is that if government is not taking any step, let's see if a private members bill could come and as a parliament of a master official who can use 1 or 2, 3 days to take the bill through all the stages.
Really?
Yeah. We do the first, because this one is not an LI. It's only seeking to amend a provision. So it's not clearing everything. They are seeking to amend only section 3(2), which gives the authority to the president for him to allow mining in forest reserves. So they are not seeking to throw out the whole LI.
All right.
As the government side is seeking to do. Now they want that even if this should stay, the section that gives authority to the president to if you can permit me, sir, let me just read that. Despite paragraph A of sub-regulation 1, the president may, subject to article 268 of the Constitution, give approval in writing to a mining company to undertake mining activity in a globally significant biodiversity area in the national interest. I don't know what national interest is served in mining in forest reserves.
They pay taxes.
Anyway. The destruction that is done, no amount of tax. That was why some of us were worried that Etiwa Forest, we wanted to mine Etiwa Forest because of some little money we were going to get from China. No amount of money can save.
I'm saying this LI went through Parliament when my brother Kofi Annan was in Parliament.
Yeah, but now let's talk about the business.
Something didn't allow me to talk about how they smuggled it through environment committee instead of the normal known committees.
So you see, let me make in conclusion. I think that
the businesses that they have tabled in the recall, from what he's saying, it won't happen. Even if there were no impediments
we must put,
for the recall.
We must put the first stage first. The first stage is for the Speaker of Parliament to take a position that he will make sure that the Supreme Court decision, the orders it has given on the stay, is respected. And you see, you said that the so-called order, they are not so-called order, they are orders of the Supreme Court. And they ought to be what? To be respected, please. And that's the point. So the Speaker should try and let cool heads prevail. Listening to my brother Kofi Adams, clearly they've taken a position. And then these are supposed to take a position. I will plead that cool heads must please.
No.
Cool heads
that's why the Speaker adjourned our Senate.
The Speaker,
so there will be engagement. Now you are forcing him to call us back without that engagement. You are calling for engagement, cool heads to prevail. The Speaker adjourned based on the exigencies of the House. Instead of allowing that engagement, because when that engagement happens, the Speaker within 3 days, he doesn't need 7 plus 7 days. Within 3 days, the Speaker can recall the House. And that is a better route.
So the engagement must continue.
So go and advise your people.
The engagement must continue, and peace must prevail in the better interest of the country.
I'm saying that.
It is not MVP or NBC. It is the country. Who else must prevail on this particular matter?
There were marching orders issued by Justin Kodua to the MPs to go to their constituencies and spend how many days every week. So even if there were no impediments, who is coming to the House?
Oh, we should also not lose out on the fact that we are in election year. We are getting very close to the national elections. Every MP ought to be seen to be vigorously campaigning for yourself and also the candidates. That is His Excellency Vice President Bawumia, who is the next president, come in January 7, 2025.
That's interesting. We are done.
Just 30
seconds. Quick.
I'm saying that, you see, in the era of cool heads prevailing, they should have allowed engagement. And the Speaker can come under Order 59, 2 and 3. That one gives a shorter time of just a maximum of 3 days.
Okay.
But if you choose to go through your request, meeting by request, which is Order 53.
7 days.
It's 7 plus 7.
It says within 7 days.
Yes, but 7, if the Speaker decides to go for the maximum, it's 7 plus 7, 14 days.
But then when the law says within, it doesn't mean you wait until.
And I'm saying that, but if you decide to wait till the 6th,
a couple of messages, and my time is running out, but this one is in celebration of Shirley Ayoko Boche on her election as Secretary General of the Commonwealth of Nations. And Bernard Mona says congratulations. Right. Thank you. I'm sorry, I'm unable to read any of your messages. So all roads leads to Asanteman Senior High in Kumasi. Have a good afternoon. I'm Samson Ladi Anyanini.